Biden administration Title IX changes adding gender identity as a protected group are now in effect. However, federal courts have issued preliminary injunctions against the new regulations in 14 states. So what does it mean for girls and women, college sports, locker rooms, at least for now in 36 other states? We're here with more is attorney Ken Tashi. He's higher education fellow at Campus Reform. Ken, remind us what this change to Title IX means for schools, sports, and locker rooms.
Hey, good morning, Gary. Thanks very much for having me. Well, the change in the federal regulations is going to have a direct and significant impact for girls and for women, both in elementary, secondary, and higher education. And under the new regulations, there's been a variety of changes that are going to be impacting biological men that identify as females, and they're going to have access to all activities and programs in the educational setting. And that's significant because that means that biological women are going to have to share bathrooms, locker rooms, showers with biological men who identify as females. They're going to have to share participation on athletic teams. They're going to have to share participation and access to, say, single-sex residence halls. So there's a whole host of events that are going to domino as a result of the implementation of these new regulations.
Ken, I know you follow the legal aspects of this, so the new regulations are in effect in 36 states. Are they going to wait to see what happens in those federal cases in the 14 states before they move full steam ahead implementing the change?
No, they're not. As of today, August 1st, the regulations are going to be implemented in those states where preliminary injunctions have not been entered. And I think now the injunctions have gone up to about 20 states. So in those states where injunctions have been issued, those institutions in those states will act under the existing Title IX regulations. In those states where no injunctions have been issued, then those states will be acting under the new regulations. And really what that's going to result in is a patchwork of enforcement of Title IX across the country, which is going to make compliance and enforcement extremely difficult.
Well, that means 3/4 of the states are moving forward with this. So what would happen to schools that don't abide by the new gender regulations?
In those states where preliminary injunctions have not been issued, those institutions as of today are going to be required to follow the new regulations. And if they refuse to or fail to comply with those new regulations, they're subject to a violation of Title IX and a federal lawsuit and potential loss of, among other things, federal funding.
Ken, how can we protect privacy rights and the rights of women, but at the same time also not discriminate and mistreat transsexuals?
Well, I think, look, I mean, the reality is that when this law was enacted back in 1972, it was implemented specifically to address discrimination and inequities based on sex and education against biological women, period. That was the intent and purpose of the law. If Congress wants to change the original intent of that law, it can do so tomorrow. It can put forward a bill. It can pass that bill through the House and the Senate, and the president can sign that bill. But modifying an existing federal law in the manner in which the Department of Education has done so is a gross deviation from its authority and exceeds its authority under federal law. And at this point, if Congress wants to act, that is the appropriate mechanism, but not through an overreach by a federal agency.
It seems like the agency is acting legislatively, and that's unconstitutional, right?
Well, indeed, and there are specific authorities that these agencies have. And let me also point out that it's very important a couple of weeks ago that the Supreme Court ruled in what was known as the Chevron case, where it overruled over 40 years of precedent where federal courts would defer to the interpretation of regulations by federal agencies. So prior to the most recent ruling by the Supreme Court, federal courts would have to defer, in this case, the Department of Education's interpretation of Title IX and its extension to protections over gender identity. Now, with that law being repealed, or that decision being repealed, federal courts will now be in the position to interpret Title IX, its original intent, scope, and purpose, and then make a judicial decision as to whether these regulations fit within the original intent of Title IX or exceed the authority that the Congress implemented back in 1972. And I think that's why these preliminary injunctions have been so successful, because I think courts are looking at the effort by DOE to expand Title IX, and they said, wait, that's way beyond the original scope and scale of the protections previously provided for.
And quickly, Kamala Harris and Donald Trump are political polar opposites on this. So how likely are gender identity and Title IX to be an issue in the presidential campaign?
I think it's going to be a significant issue. Obviously, and correctly, they have very different opinions on this. And again, I want to underscore the importance here of putting the authority back in Congress to make decisions about federal law. Every year or every 4 years, it's like a ping pong match where a new administration comes in and modifies or alters existing regulations, and there is absolutely no certainty within higher education every 4 years as to how they are supposed to interpret and enforce Title IX. So that's another reason why we need to get a federal agency out of the interpretation process and put that back in the hands of Congress or the courts.
Okay, back and forth. That's where we are now. Ken Tashi, Higher Education Fellow at Campus Reform. Good talking with you again, Ken. Thanks for being with us.
Gary, thanks very much for your time.